We spoke to Julius Grey yesterday. We thought there might be a decision reached on the request by McGill for that injunction to dismantle the encampment. It didn't come, but it did come earlier this morning, and Julius Grey has joined us, or will join us again right now. Mr. Grey, thanks again for your time. Look, when we spoke yesterday, you told me about the people you were representing in this. I asked you what you thought would happen, and of course, it was impossible to know yesterday, but today we found out the judge decided not to grant the injunction that McGill had asked for. I heard you earlier today on CTV News Channel. I'm just wondering if you'd explain to our listeners why you think that happened. Was it the urgency that McGill attached to this that was mainly responsible, do you think?
Well, I think the judge was very orthodox and very sound in his reasoning. Injunctions have three stages. You have a provisional, which is what it was yesterday. It's decided mostly on the basis of urgency. You have interlocutory, where it's partly the strength of the case and partly the other elements, and then you have a final where they just decide the case. Now, on the urgency, it's not enough to allege that there's a fire threat or a hygienic threat. You have to prove it. And the affidavits that were filed by us, I think, were quite conclusive that there is no threat, and even McGill agreed there was no violence. So the judge put it correctly when he thought, he asked, can you do a prophylactic injunction in case something arose later? And I think the answer is no. The other aspect, which I think is very important, is the judge gave due importance to demonstrations, manifestations as a way of protesting. He pointed out the context, the Gaza disaster, and the fact that there is a human rights issue. He didn't have to decide it because at this stage he doesn't decide the law. But altogether, it is a very encouraging decision which puts basic rights at a par with property and doesn't give an automatic priority to property.
So I have a couple of questions, and this has been raised by listeners as well when I asked the question, their reaction to what we found out today. First one is this. McGill says this was urgent, and I understand, too, the judge at one point said, if this is urgent, yet you've already made plans, a plan B, if you will, for your convocation ceremony somewhere else, I guess it's not that urgent. In a sense, I'm guessing that's how he said it. But the other question is, if protesting is your right, and we agree that in a democracy it is, what about this idea where people say, look, you can protest all you want all day, but then at the end of the day, go home, you can come back tomorrow and protest again. Does that not apply?
Well, that's an idea that some people have, but I don't think that's established anywhere in law. And I think we're going to try to argue that a sit-in or an occupation is part of the panoply of protests. Now, of course, no one claims that this installation is permanent. Obviously, it's not. The Vietnam ones were not the ones I participated in many years ago, and this one, too, is not permanent. But I think the right to make the splash by sitting in is an important one. And for instance, for my clients, who are both Palestinian and Jewish, it was essential to show what few people know right now, that there is not a single two solitudes idea where all Palestinians think this and all Jews think something else. There is a possibility for them to work together and to cooperate and to appreciate each other. And I think it took the demonstration, the sit-in, to make that point. It's not permanent. It's not forever. But I think it was an essential part of the protest.
You said repeatedly it's not permanent, yet this same group says we're not leaving until we get what we want, which makes me wonder, if you don't get what you want, are you here forever?
Well, I don't know. There may be a time at which the court will say no. At the interlocutory or at the final statement, they might say, this has been gone on long enough. Certainly it wasn't permanent in 1968, 69, when I was involved in protests over Vietnam and over other such things. So, no, it isn't permanent, and it's not forever. But I can understand why they say that, because they want to make the point. And the judge, in fact, conceded when he looked at the context that the Gaza tragedy is a reasonable context for people to be very worked up and to protest.
So I guess my next question is, and I heard you mention that May 21st will be a next date for McGill to go back to court. What happens at that point?
Well, at the interlocutory, it's a somewhat different mix. You have to look at the strength of each case. You have to consider the property versus demonstration side. Urgency is not so important, but balance of convenience is. Who's going to be more hurt if they don't get their way, the demonstrators or McGill? McGill can also appeal. Some people think that they might. I think in this type of case, deference is due to the trial judge. And there's no way that one could argue that he did not, it was not based on the evidence. But that's another thing McGill could do. I hope they don't. It's a terrible waste of money and time. And they can get the interlocutory hearing and then see what happens. But I'm certain of two things. The right to demonstrate in even sit-in is part of things that are essential in bringing important issues to society's attention. And it's not permanent. No, it isn't. But it has to last a reasonable amount of time. And the question is how reasonable in order to fulfill the purpose of the demonstration.
Which would be my last question with respect to what's reasonable and what's not and who gets to make that decision. When does McGill finally get to say, look, they're on our property, we would like them to leave, we think this is enough?
Well, what was argued is that McGill property, like government property, is not like our backyard. It's not purely private property. There is an aspect where universities are places where people meet and exchange ideas and protest. So, and McGill admitted that. And the same applies for government property. For instance, there's been a case of the Supreme Court allowing political activity by various groups at Trudeau Airport. So it's not a clear-cut property issue. Not like somebody says somebody's come in and camped in my backyard. It's not that. It's how much is the public side of the university to prevail over the technical ownership of the land.
Okay. Mr. Grey, very much appreciate your time. Thanks so much.
Thank you.
Pearl Eliadis is a human rights lawyer and associate professor. She's actually at McGill's School of Public Policy. Pearl, you heard everything Julius Grey had to say. I want to get a take from you on what you heard today. Look, I want to be perfectly honest here. When I ask listeners about this, there are a lot of people very upset about this. I think most are. Some are not. Some are saying, you know what? It is and has been a peaceful protest, and as long as it remains that way, I'm okay with it, right? That's been the attitude from some. But I want to ask what you think is next here.
Well, I think Julius mentioned, quite clearly what happens next, which is that they're barring an appeal on the provisional injunction, which I agree with him, I think would be ill-advised on McGill's part. They should take the opportunity to refile the proceedings with the changes that the judge asked them to make and to move on to the interlocutory stage, which looks at a different set of tests and allows McGill to get into some of the details around the issues like the ones that some of your readers may be upset about, to get to those issues a bit more clearly. But they clearly, manifestly on the face of the judgment, the judge basically said, look, you have not met the test for urgency. That's the test. If you're going to, and let's not forget, this is a procedure where the other side is not fully present, if you will. This is what they call an ex parte procedure, or it can be an ex parte procedure, meaning that the other side isn't even heard, and you have this sort of John Doe situation, which was we've discussed before, and so you could have potentially have had all of these people unnamed be the subjects of legal proceedings on which they had not been advised. I mean, it really at many levels procedurally made no sense. So I think that the judge was right to move it on to the next stage, and McGill's rights are not affected in doing that.
So I have a couple of questions. I don't know if these are fair to ask necessarily. I heard Julius Grey talk about the fact that it was quite interesting to note he was part of, the anti-war protests at McGill back in the late 60s, I guess. And then we've had other encampments in the city, most notably, most recently, I guess, the Occupy Montreal movement, which ended up in front of Victoria Square, was there for quite some time, and was broken up eventually, as some suggest, by virtue of the fact that winter came. But where is that reasonable time for something like this to be allowed to continue? I mean, what do you use as the parameters to decide what reasonable is?
Yeah, I heard you asking Julius that question as well. It's a difficult question to answer, Aaron, because as long as they stay peaceful and as long as the business of the university has not been affected, the balance, if you will, so far has weighed in favor of the protesters because they have these rights under the Quebec Charter of Rights and Freedoms to not only freedom of expression, but also, and this is important, peaceful assembly. And peaceful assembly, there has been case law in Canada on this, can include a temporary occupation, including temporary structures, quite separate from the right to freedom of expression. So there has been that case law in Canada. We do recognize it, and then the question becomes, how long is too long? Look, these are temporary structures. Worst case scenario, winter comes and everybody goes home. Between now and the winter, I think we are going to have that interlocutory decision, and the courts are going to start to look at things like sanitation, the safety issues, but McGill was unable to prove those things. And I think the point that needs to be made is that in a democratic society, we need to have these safety valves. We need to have these, spaces for people to sound off as long as they're being peaceful, because that's what creates, in the longer run, a democratic society, even if I don't like what you're saying. That's what differentiates us from an authoritarian regime.
All right. Pearl, as always, I very much appreciate your time and the input. Thanks so much.
Not at all. Take care.
Pearl Eliadis, there you go. That's part of it. Julius Grey with the other part of it. We shall see what happens next. And interesting, they both said the same thing, that it would not be a good idea for McGill to appeal this verdict today, this injunction being denied, but they will go back for what they call that interlocutory trial agreement, whatever it happens to be, and try to present different evidence that will try to convince a judge to grant them an injunction to have this encampment basically dismantled. That's at least a week away.